I'm Andrea Wallace. I guess kind of before I start, I want to give you a little bit about the background of me, because I went to art school before I went to law school, and part of the empirical evidence that I'm going to be presenting may sound like I'm taking a position in kind of what I assume cultural institutions are doing and a lot of the information that I've been gathering behind the scenes, but I want to be clear that I'm not. I'm remaining neutral, but this is a lot of kind of what the evidence is presenting itself as. So now I'm currently with the University of Glasgow and the National Library of Scotland in Create, working on cultural institution, copyright, and technology. Do I just press? That didn't work. There we go. So where cultural institutions are coming from within this context is that they're facing a lot of challenges. Collections are at risk either because of the sins of others, or there's a lack of funding, and there's this kind of this mass movement of a way to generate more financial support in order to support the collections. Plus, there's new competition that's developing in the digital realm that's changing how institutions attract audiences and stay relevant, but also how they're operating within their own institutions as well. So what's clear is that digitization is the new norm as a way to reach audiences that are no longer local or national, but also global. It also presents a lot of challenges for how to digitize the collections depending on the type of content that the institution has. But it's also very expensive. So anything from taking an image to scanning an entire book and trying to put that through some sort of processor to extract all of the text, it can cost a lot of money. And when cultural institutions are losing money, they're turning to their collections as a way to monetize and support producing revenue in order to further this mission. So this is largely why they're starting with the public domain. For one, you avoid a lot of copyright clearance searches, a lot of the expense that comes along with copyright. But what I find really interesting about a lot of this is that these are objects that were never intended to have copyright protections in the first place. So in digitizing a lot of the images digitizing a lot of the works that are in the public domain, cultural institutions are starting to restrict access to the digital reproduction. And what we're starting to learn is that an image or an item that was once in the public domain no longer remains in the public domain. This is becoming a common practice. As you'll see, there's sometimes watermarks and outright copyright over the object. We have down at the bottom right the National Archives. This piece is, I think, shipping records for World War II, but you can't look at it even from a scholarly perspective to see if it's relevant to your research because there's abstractions over it, but there is a nice little tag at the bottom that will say this item is available for free if you'd like to visit the National Archives. Otherwise, you can pay a minimal fee, sometimes anywhere from £3 to £8 in order to get the digital copy of that, and then look through it wherever you are located. So in some cases, you can see it's not even viewable online, so it's restricting access for the digital reproduction. And this is all happening because there's a lot of holes in current legislation. So several trends are becoming common practice that essentially enforce copyright over the digital reproduction. Now, my current research is kind of looking toward the UK, but I'm expanding this here into the US. What I've currently found with all of these cultural institutions is that they impose their own copyright on the reproduction of the digital or the public domain item. I have to give a shout out to the National Library of Wales because on their website they explicitly state that they don't. So whatever the underlying object is, those copyright protections or the lack of will also apply to the digital reproduction. However, this specific provision is located in their intellectual property rights policy. It's not in the policy that's titled copyright, nor is it in the terms and conditions of the website. So even trying to find this information becomes really, really difficult for the user in accessing the website. So you would think that if cultural institutions are doing this, then what's fair for cultural institutions would also be fair for you as an individual, right? Wrong. So also through the terms and conditions of the websites or through the license that they provide for you to enter into their physical location, they restrict what you can do even in making your own images. So my favorite example is Classical Life. Even if you're going in to sketch from their collection, you're supposed to obtain a layer of permission just to draw. Then in order to use your sketch, you're supposed to obtain another layer of permissions, either to print that or to even put it in some sort of presentation like this one here. And then if you do print or publish it, you have to deposit a copy with Glasgow Life for them to keep on hand. So some of these can get really, really complicated, and they're listed in language that the people who they're supposed to be impacting wouldn't normally be able to understand. So this is where this surrogate copyright, or the copyright by contract phenomenon, is starting to occur. Because if you access the general terms and conditions of any of these websites, it will say, by using any content, you are deemed to have agreed to them in several different places. They're claiming copyright both over the images and the data, often, that is also in the public domain. And it creates a property right that previously did not exist. Also, by the standard terms and conditions, they're making them more expansive than copyright protections would allow, essentially creating a contract of adhesion just by accessing the website. So the reason that I'm also referring to this as surrogacy instead of ancillary is because the copyright protections no longer exist, right? So this is public domain, they're not ancillary to anything. And then there's these layers of surrogacy. So the image or the digital reproduction itself is a surrogate for the actual object. The rights that are being created are surrogate rights that may have previously existed or are created that resemble rights that might exist for other legitimate items. And then they're also being claimed by a surrogate party. So in this instance, it's Victoria and Albert Museum. That's an extract from their website. That's just in the terms of use. And these are the layers that it applies to this specific institution. So one thing that I'm trying to also achieve in my own research is how to visualize this in a way that's actually understandable to a user. So this is a sketch for a larger chart that I'm working on, but I've been reviewing all of the different terms and conditions. At the very bottom, we have examples of websites where literally all you're allowed to do is to access it via the website. It will explicitly say you're permitted to access our images temporarily while you are on our website, and then that's it. Other institutions will negotiate a one-time non-exclusive use that's also limited in time. So if you see on the bottom, normally what you're getting all the way across on the left-hand side for non-commercial use is a low-resolution website image. Then as the resolution gets better, or as you kind of decide to use it in a commercial manner, then the access that's permitted starts to go across that scale. So if it's access only versus personal study versus academic or scholarly purpose, and then all the way over to commercial. Then on the y-axis, technically where the private comes invoked. So you can see with the National Library of Scotland, National Library of Wales, where they're just actually trying to promote access and allow people to get a hold of the information that's contained in their objects. I think they charge anywhere from £3 to £12 for some sort of digitized image. But if you go to the British Museum Images or the British Library, it can get really, really expensive. Specifically, this is how it's playing out. So a lot of these websites have something called a price calculator. And you'll go in and you'll kind of register what type of use that you would want. If you look in the upper right-hand corner, I was supposed to pay £50 for this use for the National Gallery for the Van Eyck painting. Another one that I can't remember from the tape because the online image is not available. Academic usage, lecture presentation, single venue entry, that's where we are today, £20. And then you can see at the bottom, it can get really expensive. So up to 1 year for a brochure cover of this Egyptian sarcophagus. With the British Museum, it's over £1,000. Then another way that I'm trying to visualize this is a chart that I made. I should also mention my background was graphic design, so don't intimidate. I'm also trying to imagine, if it's this confusing for me, then how do we take this information and present it to a user in a way that actually is clear, helps them understand what they can and can't do on a website, and then is kind of translated into things that they would actually understand. So can I draw or sketch on a visit? Can I take photos? Can I reuse photos reuse the photos that I take during my visit? And then I'm also trying to put this in a way that I'm not making any conclusions. I'm allowing the user to make the conclusions, right? So you look at the total green columns. One is, can I view images on the website? Of course you can. But then you go all the way over to the right, can I pay for extra use? Of course we'll accept your money for that as well. So there are these things that are starting to reveal themselves that cultural institutions are really looking to what other people are doing and making their policies, understandably, but it's actually starting to have a real impact on access and use as it becomes limited in the public domain. So another group that we're looking at is orphan works that are in purgatory. And I say purgatory because often we don't know the death of the author, we don't know when it does transfer over into the public domain. And the UK has an orphan works licensing scheme. So what happens is you would fill out an application, the initial cost is £20 for one application, it goes into review by the Intellectual Property Office, they'll either grant it or deny it, they'll request that you pay a licensing fee. It's dependent on the use. It can be anywhere from 10 pence for non-commercial up to an application we fill out in the National Library for 2 hours of commercial film use was £62,000. And don't forget, this is exclusive to the UK and, it's exclusive to the UK jurisdiction, and anyone technically could sign on and also license that work as well. So it's a non-exclusive license. And then you would take that license to a cultural institution in order to get access. But what's happening in practice is cultural institutions are actually recommending that the people who come to them first take out copyright insurance. They will say, well, there's this legislation that does exist, and if you'd like to go about that, then you're perfectly happy to go do that. But we're going to charge you for our fee as well. We're going to have you sign this indemnification clause, and then you will take out copyright insurance in case anyone actually does come forward and try to sue you for infringement. And this is especially the case with corporations like the BBC that need to go to archives and get filmed sometimes the same day. They don't have 10 to 14 days to file an application through the Intellectual Property Office in order to get that footage. So then that was what, October 2014, and it was supposed to make 91 million works available. I just checked this morning and there's now 277 results. But what's happening is most of these images that are being registered are actually still images, so they're photographs. And if you go through them and look at them, most of them are actually in the public domain. And we can tell that because there's an exception. If a photograph was taken by an unknown author before June 1st, 1957, then there's an exception built in that all of that is in the public domain. That constitutes World War I, World War II photography, so you can look at the image and you can see right there and then that that's a public domain work. But the Intellectual Property Office has taken this kind of, if someone wants to pay for it, we're going to let them go ahead and license it. But it's still assigning rights to works that have long expired. So this also extends to moral rights. Now, cultural institutions are trying to keep up with everything, and understandably, it's taking a little bit of time to adjust their policies and digitize everything to do that. So they have been making donations and massive uploads to like Wikimedia Commons, Europeana, and Flickr Commons. But they're doing so through these Creative Commons licenses that sometimes end up creating perpetual moral rights, because if you look at the BY, that means attribution. SA is share alike, so anytime that you use that image, you also have to share it with those same licenses on it. So not only are you attributing it back to the author and then the institution, but anytime you share it, you're doing that as well. And we know that moral rights are supposed to expire and reburn with economic rights. So these are rights that no longer exist, right? If it's a public domain work. And then Creative Commons is actually re-implementing them back into the metadata of all of these images. So in the defense of cultural institutions, these are the types of things that happen when they are fully public domain and people don't respect the rights. So we have this Twitter account, it's Social Chain. It was actually a 19-year-old that was hired to kind of make new accounts and see if they got popular. It started in March 2015, and he has more than 300,000 followers right now. He takes all of his images from the British Library, British Museum, puts up funny sayings, and then it passes around on the internet. Well, it's violating all the terms and conditions of the institutional policies, but it's also not attributing them back. So there is this damage to digital cultural heritage in that someone who might be interested in the underlying piece can't figure out exactly where to go in order to study that. And then another issue that ends up developing along with the data and the metadata, the yellow milkmaid syndrome, is a paper out of the Netherlands that focuses on a business model perspective to what's happening with metadata in the public domain. So it basically exposes when there's not control taken by a cultural institution, when they don't put a high-resolution image up with the metadata attached to it, with the correct attribution, and take control of that discussion in the public domain. We have instances like this. It's a piece at the Met. There's multiple different examples online. So the public doesn't have an accurate representation, either of the image itself, or the coloring, or the quality. You can see there's various different sizes on various different locations of where someone actually essentially end up if they were trying to do research on this type of work. And then if you do a Google search, this is also what ends up. So if you kind of go back to the yellow milkmaid syndrome, anytime that you would essentially be looking for one of these pieces, then you have all these almost bastardizations that reappear along with the original item. So you might be familiar with this piece, but you might not be familiar with the piece that you're trying to research and get more information on. So it actually does a disservice to you as a researcher if you're trying to figure out what the original image is. So, in my opinion, all of these surrogate rights that are developing, it's a short-sighted solution to how to actually control the content that cultural institutions are putting on the internet. One way we can look at that and see the exact opposite approach is the Rijksmuseum, which was closed for 10 years. They digitized their entire collection, resolution where you could literally print a wallpaper of one of your favorite paintings. They have something called the Rijksstudio. You can download all these images right on the homepage, good artist copy, great artist steal. So they have their collection available for you to make your own pieces. It's commercial, non-commercial, you can cut them up, you can do whatever you want with them. And understandably, a lot of people don't have that money to do that, but the Rijksstudio decided to invest in this because they do something called the Rijksstudio Award every year, where they let you submit your projects back to the Rijks, then they pick the best 10, and then the winner gets €10,000. It generates a lot of interest in the collection. People have to go online and register in order to download these images. And then they track the data of what people are accessing, how they're using it, and they can actually curate their collection in a way that makes the physical location more attractive. And I don't know if they're doing this, but they're also collecting the personal data that they could essentially turn around and sell and monetize that as well, right? So it would kind of replace the image revenue generation as opposed to the data revenue generation. They even have partnerships. This image on the left is an Etsy example. So they have a partnership with Etsy that you can click through their homepage and see how people on Etsy are using their collection to create new products. So in conclusion, if it's this confusing for public domain works, it's even crazier when you get to copyright works. This is Google Cultural Institute. They couldn't get fair use in order to take the street view camera through all the different galleries of some of our favorite institutions. So it effectively amounts to censorship because I feel like the general public would say, absolutely, that's fair use, right? Like there should be no reason that Google can't take this technology and go through their galleries and then make it available to the greater public. But the law says, no. It's a commercial use, it's not fair use, we're going to make sure that it kind of stays boxed up. So that's me. Any questions? Go ahead.
I guess this is a question about methodology. Are you, to what extent are you learning and describing about this from what you can perceive on websites and other public materials, and to what extent are you pursuing like interviews and conversations with people? Because there's stuff I imagine that might be behind the scenes, like I'm wondering, are basically all of these art museums being approached by a for-profit company who's like, we'll digitize your collections and help you monetize them, and here's how to do it, or I don't know, if you've had interviews like that, what are some of the interesting things coming out of it?
Well, I've been sitting in on all the National Library meetings because we're basically going through a rebirth of all their policies. And they're trying to make it as open as possible, but because there's no legislative guidance, they're also being a little bit hesitant. So they're kind of doing it in phases, and they're thinking like, okay, well, this is what we'll do to this point now, and we're happy to go farther, but we want to make sure that we're, not kind of crossing any lines. They're also, this takes a lot of time. It takes a lot of time to get people into the same room. It takes a lot of time to get people to kind of approach this open access and open data mentality and accept it. And they're all looking to what everyone else is doing. That's holding the group back as if, looking to your peers. Because everyone is kind of turning to other institutions to see what they're doing and making their decisions. So I have talked to a lot of people. I've talked to people at Europeana, and they're just like, well, no one knows what to do. So it's kind of this, it's important to, I guess, set out these issues and determine the right path to take, because those are going to be the paths that people look at, which is why the Rijksmuseum is such a unique model. Hopefully other people will follow their example, because there's very clear benefits to doing it, but everyone's just a little hesitant at the moment.
Can I ask you a slightly provocative question?
Yeah.
If you go back to the Rijksmuseum slide, what does that mean exactly? Good artists copy, great artists steal. I mean, it's a quote, but what exactly do they mean by having it up there? I mean, I missed part of your presentation, so hold on.
No. Well, I think in this instance, they're saying these are public domain items, so they're free for you to steal. You know, it's taking the cultural goods and repurposing them for future generations.
So that's like, sorry, that's what they're offering as an activity through the studios.
Yes, yeah. All of their works have been fully digitized, really, really high resolution, and that this Rank Studio Award is a competition among the general public that they get, like people have printed images on motorcycles, they've made packaging for products, so some of it's personal, some of it's commercial, some of it's, you know, they're making money off of it, but the Rice has taken a position that they're fine with that.
And would you, I mean, as a person commenting on copyright policy, would you think of this?
Well, if it's public domain, it's fair game, that's right. Yeah, because it's only, the entire Rice collection is public domain.
If it's public domain, it's not stealing.
Right, exactly, right.
It's a strange label.
Oh,
I'm good, I'm sorry.
my question is, this is fascinating. I think it's really interesting. My question is, what's the risk by just ignoring these terms of use? So if it's a public domain work, and what they're essentially imposing a contract on you, saying you're going to agree by contract not to use it. You can't enforce the intellectual property rights. All you have is contract rights, which are you have to prove it's not.
Yeah.
There's not a moral termination. They have to prove
Right.
damages. So if there's a public domain board, what's the damages that they could?
Well, no one's really trying to enforce it yet, and everyone's just waiting for that to happen. And I've talked to some of the people who are at the Museum Sciences group in London, and this isn't an exact issue that we discussed. But some of what the terms and conditions that I think are really interesting, like the Victorian Albert, they have you register, and they'll actually give you kind of medium to high resolution images. And they say you can use these non-commercial, personal study, but if we find out at any point that you used it commercially, then we will retroactively apply whatever fee we would have charged for it to you. So it's, in a way, I think they're trying to almost take their terms and conditions and make them enforceable, right? Because that's one way for them to get around it, but not necessarily find